attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation of a Lawcast series discussing Rule 506 of Regulation D, including the difference between a traditional Rule 506B offering and a Rule 506C offering that allows for general solicitation and advertising. In prior Lawcasts in this series, I have been drilling down about the question of what constitutes general solicitation and advertising for purposes of determining whether a particular solicitation would require a company to comply with Rule 506C as opposed to 506B in connection with their offering. As a reminder, under Rule 506B, sales can be made to an unlimited number of accredited investors and up to 35 unaccredited investors, and a company may rely on the investor's representation as to their accredited status. They can check a box or self-verify. Under Rule 506C, sales are strictly limited to accredited investors, and a company must take extra steps to verify accredited status. They cannot rely on the investor's own representation. Also, as talked about, SEC interpretations and case law have established the principle that where there is a pre-existing substantive relationship with offerees, offers to those offerees will not be considered to have been made by general solicitation. A pre-existing relationship is one that the company or someone acting on the company's behalf, such as a broker, dealer, or investment advisor, has formed with the prospective investor prior to the commencement of the offering. The existence of a pre-existing relationship depends on facts and circumstances. There is no set minimum amount of time that a relationship must exist to be considered pre-existing, but rather it is the quality of the relationship. A substantive relationship is one in which the company or someone acting on the company's behalf has sufficient information to evaluate and does in fact evaluate such prospective investors' financial circumstances and sophistication and confirms that they are accredited. Self-certifying by checking the box is not enough to establish a substantive relationship. However, a company can create a process to create a pre-existing substantive relationship. On August 3, 2015, the SEC issued a no-action letter to Citizen VC related to its procedures for creating online pre-existing substantial relationships with prospective investors, such that subsequent offers and sales to those investors would not constitute general solicitation and advertising under Rule 506. The SEC confirmed that Citizen VC's procedures were effective to establish a pre-existing substantive relationship. I urge people to review the entire letter, which is available on the SEC website. However, as a summary, Citizen VC had the following procedures. Citizen VC has a publicly accessible website, and potential members can initially apply for membership using a publicly available application on the website. Citizen VC only solicits its members, not prospective members, but only its actual members for investments. Particular offering documents and offering information about portfolio companies are all password protected and only available to members. Citizen VC has written policies and procedures in place for establishing a relationship prior to accepting an application for membership. The specific procedures include contacting the prospective member offline by telephone and having person-to-person discussions related to such prospective members' sophistication, financial circumstances, and ability to understand the nature and risks related to the types of investments Citizen VC undertakes and will solicit. Sending an introductory email. Contacting the prospective member online to answer questions. Utilizing third-party credit reporting services to confirm the member's identity and to gather additional financial information, including a credit history. Encouraging the prospective member to explore the website and ask questions about Citizen VC and their particular special purpose vehicle managers, investment strategies, philosophy, and objectives. Fostering both online and offline relationships between Citizen BC and the prospective member. So that is a list of all their processes and procedures. Moreover, the prospective member is informed that offerings have a minimum investment of at least $50,000 or higher, and many are significantly higher. A membership application is only accepted after Citizen BC is satisfied as to the accreditation and sophistication of the potential member, and as mentioned, offerings are only presented to established members. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.